just so you have an overview of a presentation. First, I'm going to briefly discuss Digital Freedom Fund. Then I'm going to make sure that we're all on the same page when we speak about digital rights. Then I'm going to speak about the significant issues that we unfortunately see ourselves facing within this realm of human rights. I'm then going to speak about regional legislative developments that are currently some of the key ones that have been happening throughout Europe, and then briefly also mention recent legal cases. So just to give a little bit of background, since I'm new to this group, my name is Nikita Kekana, and I'm part of the Digital Freedom Fund. And basically what we do at the Digital Freedom Fund is we advance the protection of digital rights through grants that support strategic litigation, which protects human rights in the digital context. And we also host many community strengthening and capacity building, both events and also documentation. For example, our strategic litigation toolkit, and our territorial scope is the Council of Europe. And I'm the senior legal officer at Digital Freedom Fund. So just so that we make sure that we're all on the same page, when we speak about digital rights really are human rights. They're broad. They're basically any human rights within the digital sphere, which includes both physically constructed spaces. So this would be where, for instance, you have devices and physical technology, but also in virtual spaces, so online spaces. And what's important to note that with tech developments and more digitalization, what we've seen is the fundamental human rights and human rights violations that have existed have continued to exist in the digital space. There's the saying of technology is blind and equal and there's no discrimination. But at the end of the day, these tools are still designed by human beings, and a lot of the issues that we've seen continues to be perpetuated in this space. Just speaking about some of the main themes, of course, there are many issues, but some of the significant issues that we've seen that have been coming around within this space, for instance, internet shutdowns within the public sector. We're seeing more and more governments across the globe shutting down protests and violating the right to protest and the rights to freedom of association rights and freedom of expression. And that's continuing. Another trend that we've seen is governmental surveillance. Government surveillance is moving online to online platforms, and this is often and usually coupled with discriminatory practices. What we're seeing is unfair focus is being placed on people from marginalized groups and activists with the surveillance tools. And we are also seeing a lot of intergovernmental surveillance tools. So for instance, someone will go to a hospital in Germany and to get treatment, and their records are then sent through to the immigration office to see whether or not they are authorized to be in the country. And that's causing a lot of discriminatory practices. We're also seeing what we call enforcement bodies inertia. And what I mean by this is basically a lot of the bodies and regulatory authorities that have been asked to come into the space and regulate the space are reluctant to enforce the laws and implement the laws properly. a very classic example that we're seeing within the European Union is in relation to the European General Data Protection Regulation, known as the GDPR. There was initially a lot of buzz when this act came into effect because it was seen as the cornerstone of digital data protection rights within the EU and supposed to be used as a guide throughout the globe. And while the a lot of the legislation and the actual rights are very good and great protection, what we've seen is enforcement bodies there've been massive delays and lack of transparency when people make complaints to data protection authorities. And there's also been a massive difference in how long and the quality of decisions that you get throughout different countries that are applying the General Data Protection Regulation. Then it's also really important in the digital rights sphere to speak about the private sector and corporate responsibility. The reason for this is that these big tech companies have massive amount of resources and funding, and in many cases are bigger than most governments. So it's really, you can't speak about the space and only speak about state accountability. And what we've seen is a lack of platform accountability in the space. And because the platforms are so powerful, and linked to that is this business of private censorship. And basically what private censorship is when, and I'll get to an example, a case later on in this presentation, but basically private censorship is when these massive big tech companies are censoring freedom of expression online and stifling good conversations and arbitrarily removing content. There's also within the private sector, a massive issue that we're seeing is privacy rights violations. And that, coupled with enforcement bodies' inertia, means that people's privacy rights are not being afforded what they deserve. So there's governmental surveillance, but then there's also private sector surveillance, usually for economic gain. And we're also seeing fake news and hate speech being significant issues within this space. And just to sort of contextualize some important regional legislative developments, we've seen within the European Union especially, there's been quite a lot of development in this space. So I'm going to speak about first the European Digital Services Act package, which consists of the Digital Services Act and also the Digital Markets Act. Basically, what this combination is going to look at real platform accountability and ensuring that there is some transparency on how these platforms are operating and that they cannot just simply do what they like, and that there's proper oversight. Then there's also the draft European Union Artificial Intelligence Act. And this is an ambitious, it's still a draft, but it's pretty ambitious because it's trying to look at the whole artificial intelligence sector and regulating it so that certain majority of the practices are then leveled as prohibited because it's unacceptable risk, or high risk, or less high risk. And the unacceptable risk, those sort of things are not, for example, you cannot just use artificial intelligence to allocate social benefits under this. And whereas a sort of more regulated but not prohibited would be the use of artificial intelligence when it comes to CVs and job applications. So it's a very ambitious but still pending piece of legislation. Then another thing that is coming into effect mid next year within the European Union is the Collective Redress Directive. What we've seen in the European Union and throughout the world is there's not a uniform practice when it comes to class actions, mass actions, and similar type of practices, which when there's violations of human rights that affect a wide variety and a group of people. So this directive, at least within consumer rights, aims to try and level the playing field within the European Union. And that's it's not specifically confined to the digital rights space, but it's massively important for the digital rights space because many of the violations that big tech do affect majority and a large group of people automatically. For example, if there's a privacy violation in a cookie's profile and cookie spanner, that typically will affect all Facebook users if the cookie's on Facebook. I'm now going to briefly also just give an overview. Of course, there are so many cases and it's a very wide space, so it's impossible to mention all of them. But just to say that there's a lot of strategic litigation that is happening in this space. And just so that we're all on the same page, when I speak about strategic litigation, we're speaking about litigation or lawsuits that have the potential to have an impact beyond the parties involved, and ones that can bring about positive legislative, policy, or social change. And the three cases and category of cases that I really want to highlight are the three that I've got on the screen. The first one is Sin versus Meta case. This is basically a NGO that it's an ongoing case in Poland, and an NGO that is assisting drug users found that their page had been arbitrarily, without reason, shut down on Facebook, and they were no longer able to help those vulnerable people in our population who need help to stop using drugs. And they have, through the assistance of another NGO, sued Facebook to understand why their platform was shut down and on what basis. So it's both freedom of expression, but also right to healthcare case and a discriminatory case. And as I said, that case is ongoing, but there have been some interim successes already, such as the government has ordered Meta to keep a copy of the page that they removed, so that if Sin wins the case, then the page will be reinstalled, and they're able to set up a new page to continue communicating with their target group and users that needs the help. Then another important trend is case, and this has been not just brought in Europe, but across many different places, has been the Myanmar cases against Meta again. And basically what they've found is that Facebook, which is Meta owns, has failed in their duty of care they failed in their duty of care towards the Rohingya people. And through Facebook, there has been a wider spread of violence and discrimination against this group of people. And Facebook is basically in a number of jurisdictions being sued for damages and causing harm, and a failure to prevent this hateful and dangerous behavior that's been perpetuated through their platform. Then another range of cases that have also been throughout different jurisdictions and are really important for the digital rights space are these Pegasus spyware cases, which are cropping up in a lot of jurisdictions. Basically, the NSO group has the software Pegasus, which is used by many governments throughout the world to target people and infiltrate their mobile devices and their computers and basically spy on them. It's typically being used against activists, and often activists that are living abroad and are then targeted. So for instance, in the UK, there's been so far it's being appealed, but there's been a successful case against government surveillance and illegal use of surveillance of an activist that was living in the UK by his country. And that's just to say that as this case, unfortunately, and this software continues to be used, and yeah, that's also brings me back to what I was saying earlier about digital issues. I mean, surveillance isn't something that was invented since we got the internet. Surveillance has been happening forever. But now with the digital rights and technology, governments are starting to use and companies are profiting through this continued surveillance. So in conclusion, that's why digital rights really are human rights. And it's really important to get up to date with the different tools in this space, because we really have to keep up to date, because unfortunately, both governments and the private sector are using these tools, and often using these tools to violate human rights. Thank you.